Good afternoon, Madam Chairman. My name is Ovide Lamontagne. I'm General Counsel for Americans United for Life. While I work in Washington, I live in New Hampshire, and I'm happy to be back here in the Rocky Mountain State of Colorado. I was a graduate of the University of Wyoming College of Law in 1985, clerk for the 10th Circuit Court of Appeals with Judge James E. Barrett, and I've adopted a daughter from Wyoming, and so we feel very well connected to this part of the country, and it's great to be back here. I have some written comments that I'd like to submit by way of testimony, and what I'd like to do is simply address a couple points that have been raised in the hearing today. First of all, on behalf of Americans United for Life, I'd just like to clarify that we're one of the oldest national pro-life organizations in the country. We were founded in 1971 by lawyers. We are a public interest law firm committed to the proposition that all should be welcome in life and protected in law. In this case, our work comprises drafting model legislation in the area of life. And among the pieces of model legislation we've drafted and worked with legislatures across the country is fetal homicide legislation. Our model legislation is in part what was used for this purpose of this bill, and I'm very grateful to District Attorney May for his kind words about the narrow tailoring of this legislation to give legal standing to an unborn child in the context of Colorado's criminal laws. That's exactly what it's designed to do. Our policy guides accompanying our model legislation, particularly with respect to fetal homicide, recommend that the term person, and then we go on to write, or other appropriate terms as used in the state's criminal code, includes an unborn child at every stage of gestation from conception until natural birth. District Attorney May is absolutely correct that the reason this bill uses the term person is because the Colorado criminal statute uses the term person. And as you will note from the amendment, or the language of the bill, it amends the current statute to expand the definition of person to include an unborn child. Contrary to what has been said previously, this is not a personhood amendment, or doesn't purport to be. It purports to be legislation that expands the criminal statute to include an unborn child as a separate and distinct victim under Colorado criminal law. Our intent here in working with legislatures on legislation like this is to do exactly what District Attorney May has, I think, quite properly articulated. I would also like to observe, for the purpose of the committee, I was struck by a prior testimony by an opponent who asked the question that adopting this bill would put pregnant women at risk. The Colorado law recognizes an unborn child in the criminal context. And I'd ask the committee to consider, does it put pregnant women at risk? The Colorado law currently recognizes the legal status of an unborn child under different types of categories of law. For example, tort law. Your decisional law by the Supreme Court of Colorado has recognized the identity and the rights, frankly, of an unborn child in tort law. Your property law in the statutes recognizes the rights of an unborn child. And you have specifically a guardian ad litem statute at 1510-403, subpart 5, which provides the opportunity for a petition to be brought in probate court on behalf of an unborn child who is defined as a person in that statute. This bill, Senate Bill 268, is not unprecedented in recognizing the discrete legal right in a particular context of an unborn child. This is not a Trojan horse for personhood. Americans United for Life does not advocate that, and we do not here today. As a national organization, our hearts cried out collectively for the people here in Colorado with respect to the tragedy that took place in Longmont. But I would submit to you that that case, that tragedy, only illustrated the fact that there is a gap in the Colorado criminal statute, and that this bill is not designed to address that specific case, but that case, as sad and as horrific as it is, underlined and exposed really the vacuum or the void in the Colorado criminal statute where an unborn child is not recognized as a separate legal entity for purposes of protection under the statute. Finally, I noted, as doing my research part of today's testimony, that even the Denver Post has editorialized in favor of this particular bill. I do not know the Denver Post to be an advocate for personhood, and I certainly think that the Denver Post, although it's a secular organization, has articulated a proper position for the committee to consider in moving forward to pass Senate Bill 268 and bring Colorado in line with 38 other states of this country in recognizing the legal standing and status of an unborn child in the context of crime. Thank you, Madam Chairman.
Thank you, Madam Chair. Mr. Is it Lamontagne?
Yes, very well.
Mr. Lamontagne, thank you for being here, and hope your travels were safe coming from Washington, D.C. We're very blessed to have your expertise all the way from the nation's capital. At the beginning here, you say that Senate Bill 268 is based off Americans United for Life model legislation. And then you go on to say that this provides unborn children, every stage of gestation, are protected under Colorado criminal laws. And then you say that this measure includes exceptions such as an abortion exception. Your model legislation that you say 268 is based off of, do you have that abortion exception in your model legislation? Or is that unique to Senate Bill 268?
Mr. Lamontagne.
Thank you. May I respond?
Please.
Thank you. Yes, in fact, the model legislation contains the exception language that you've alluded to. It's, I believe, verbatim. We believe that the definitions are properly expansive to incorporate various types of surgical abortion as well as chemical abortion. That's the second and third exceptions. And finally, respects and protects in the law, whether we like it or not, under Roe versus Wade, that it is the woman's intentions here that are respected, and that if she consents to terminating her pregnancy, aborting her child, that is her protected right. This statute does not purport to change that.
Senator Kerr.
Thank you, Madam Chair. And thank you, Mr. Lamontagne. And then I find it curious that Americans United for Life in their model legislation would draft an abortion exception, since you're here at the beginning. It says the vision is a nation where everyone is welcome in life and protected in law. That seems to go against your vision, but the other thing I was curious about is, I get in your testimony you say that this is about protecting the safety, protection of life, but that this has nothing to do with abortion. Right. But yet your testimony, you specifically talk about that. Can you help me? Is Senate Bill 268 about abortion, or is it not about abortion?
Mr. Lamontagne.
Thank you very much for the question. Senate Bill 268 is about life. It has nothing to do with abortion. Our organization, as well as a number of other organizations, but particularly ours, is committed to protecting life. Our focus is being for life. While we may have issues with the pro-abortion industry, our purpose is to try to find ways in which life is protected and affirmed in law. And that's what this particular legislation does in the context of a criminal statute. It fills a void which is created by the common law, which essentially says that a life isn't protectable under the criminal law unless a person is born alive. But today, ultrasound technology, the science shows us that life is in being well before the person is born alive. So that is our perspective. This is about life. It has nothing to do with abortion. And candidly, we've been criticized by some pro-life organizations for working collaboratively with legislatures across the country to achieve this kind of recognition and protection of life. But that's our focus, what's possible under the law to protect life.